4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
Welcome to the microphone, welcome to the studio, Andrew Bell from Bell and Senior Lawyers. Good morning.
Good morning, Colin. Less soggy today. Hope everyone survived all the wet.
I was going to say, did you float your way in? Or it was wet last night, wasn't it? It was a lot of places in flood. I think you were telling me that Mudgeeraba got a battering.
Mudgeeraba got a battering, and I live on a hill and massive logs going down. We lost power on the way home. I was in massive amounts of water from Southport home, but hopefully everyone else survived.
Yeah, I hope so too. All right, this is a talkback program. We'd love to hear from you. 0755 208888 is the number to get some free legal advice this morning. Right here on the radio, 0755 208888. Now, I'd like to also point out that Legal Matters is a brand new program. We did have an older program, brand new sponsor, Bell and Senior Lawyers. Good morning. All right. Well, let's do a bit of a recap of last week, but we did have a caller last week that you would like to update some information on.
We did. We've had Rod call in twice about what to do about trees growing over your fence. And as I've said, it is your obligation to look after trees. If your neighbours ask you to cut them down, they are able to remove your branches up to 2.5 metres tall by themselves without consulting with you. Rod was very concerned about any costs. He'd offered to the body corporate next door to remove the branches, and they hadn't got back to him. Well, I've clarified this week, dusted off the textbooks, and so what has to happen is a Form 3 notice can be given where they can say, you've got 30 days to do something about this, or we will include a quote and you'll be liable for up to $300 of removing those branches. Well, it is possible for you to respond to that about when you're going to remove them and which contractor you're going to remove. You have to nominate some dates that you'll be available to do it, and that gives you the right to go onto their property and remove them so they don't give you the $300. So if you're really worried about the cost of your branches overhanging the fence, well, there are things that can be done. So I would say offer to clean them up if you're worried, and otherwise wait and see if they issue you a notice and then respond within the time frame.
Nice. Well, there you go. Sound advice. Well, we've been talking administrative law last week. We're going into part 2 of that, but I'd like to remind you this is a talkback program. We'd love to hear from you this morning. There is around about 23 minutes left in the show. Do not leave your call or your question to the last minute. Andrew, I'll let you summarise last week.
So last week we talked about admin law, or administrative law, which for those who are unclear is challenging governmental decisions. And it's using the actual framework in the law to be able to do so. So we looked at last week the Planning and Environment Court, we looked at merits review, we looked at judicial review. And you can go back on the 4CRB website to listen to that to bring you up to date. But essentially there are strict timelines that you need to adhere to, and then there's guidelines that the minister or the body making the decision needed to make decisions. And if they didn't follow those properly, there are avenues for appeal if you're within the time frame that can actually go through and then decide whether those decisions were made within the remit of what they were, or if they had to be returned as well. So those are the legal options that you have, and it's quite an advanced area of law, not something you come across every day. But there are also things that you can do that don't follow the legal system that can also apply pressure on decisions which may or may not be more effective. So today we're planning on going through some of those.
Perfect. 0755 208888 is the number if you'd like to ask a question of Andrew Bell from Bell and Senior Lawyers. Let's start with avenues that don't require a court. The Ombudsman. What can they actually do?
So an ombudsman is a Swedish term, and it's an outside regulator who helps work with the government and the people. And so there's now ombudsmen across many areas, whether it's telecommunications, the Queensland Government, the Commonwealth. And they investigate complaints about departments, agencies and councils, and sometimes also about private businesses that are regulated. When I worked in telcos, the telecommunication ombudsman always drew fear in the heart of telco companies because people are often complaining to them, and they are very effective at getting customer-led resolutions.
Oh, yes. I do remember a time Vodafone bought another company and just piled them onto the network, and basically you had to make 5 phone calls to finish a conversation, and I believe the Ombudsman got quite a few calls on that one.
Indeed they did. I actually worked for the company that sent out the first alerts on mobile phone plans, where my software would work out if you're actually going to go over your bills, because otherwise they were getting inundated with complaints to the Ombudsman around people not being able to afford their phone bills. So we put in a system of warning people, which was obviously a lot due to the pressure from the Ombudsman. So to use an ombudsman, they're typically free. You don't need a lawyer. There's no filing fees, and it's accessible to any member of the public. You've just got to find the right ombudsman. So the ombudsman isn't a court. They can't necessarily overturn a decision, but what they can do is investigate whether the body followed the rules or not. And if they found it was defective, they can make recommendations to the government agency or the minister for them to be followed. And those findings can also be made public and potentially be used in any court actions later. So for people who've been ignored, if you don't feel your submission's been read, your correspondence wasn't answered, you feel that the rules weren't followed, if the legal process we outlined last week is too difficult, I'd recommend that you consider contacting an ombudsman. They're low cost. They give you a formal response and keep a written record of what's happened.
Absolutely fantastic advice. Having availed myself of them in the past, they're well worthwhile as a good start. What about the Queensland Human Rights Commission? When does that become relevant?
Okay, so Queensland relatively recently, in 2019, passed the Human Rights Act. And what this act is, it requires all Queensland government entities to act in a way that's compatible with human rights and genuinely concern people's human rights when making decisions. So this could be a right to privacy, the right to your culture, which is particularly important for Aboriginal and Torres Strait Islander peoples, but not exclusively them, the right to equality, the right to a fair hearing. So what this means in practice is that they can't just make a decision in isolation that badly affects people without considering their human rights, which is actually a very important stopgap. So if someone believes that a government decision did violate their human rights, for example, failed to consider the cultural rights of the traditional owner, gave you a fine that meant that you can no longer have a livelihood, did actions that go beyond just simple we followed the rules and you've been impacted, but actually impacted your quality of way of life, then you can actually make a complaint to the Human Rights Commission. They can investigate and conciliate, and in serious cases, the Human Rights provides a further it must have been the rain. Too much everywhere. But in serious cases, the Human Rights Act provides a further basis to challenge a decision in the Supreme Court. So it's an additional arrow in your quiver, and it's particularly powerful in cultural heritage and environment matters, such as we discussed last week.
All right, we've got our first caller this morning. We're going to move to William. Good morning, William. Ask your question about Andrew.
Good morning. We sold some stuff through an online company, and we dispatched the product to the buyer. Mm-hmm. When he received it, the envelope had been opened, the contents had been taken. We've approached the post office and said, we don't cover that item in the postage, and there's no compensation as it's insured for up to $100. How do we stand?
My understanding is that that's the default position of the post office, that there's insurance up to $100 by default with normal mail, and anything above that you needed to apply for insurance to be covered. So in your example, if you didn't have insurance, there is a process on their website to make a claim about damaged or lost goods to avail yourself of their insurance, and they may ask for pictures, a statutory declaration, etc., and you may be able to be compensated up to $100. However, anything more than that, I believe they have statutory protections that they don't have to compensate you for more than $100.
Yeah, it was for less than $100, but near that mark. But who should put the claim in, the buyer or the seller?
I believe either can. Typically, a seller would be then resending it out and resending a new item out to the buyer if they have one. So they're the ones who suffered the loss. So the buyer would put it in. And technically, the contract is with the person who put it in the mail. So if possible, I'd recommend that the seller puts in the claim. But I believe either can. But I'd follow the advice on the Australia Post website.
Thank you very much. Okay.
Thank you, William.
Good on you, William. Well, that was an interesting one. This is a talkback program. If you'd like to ask a question just like William did of Andrew, 0755 20 8888 is the number. 15 minutes left in the program. We might go to a word from our sponsor.
Wills, probate, powers of attorney or property matters are legal issues that can feel overwhelming. Don't put off dealing with them. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 55 32 8777 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple.
All right, we're back. We're talking administrative law, but that doesn't limit your questions to Andrew this morning. All you need to do is give us a call right now. 0755 20 8888 is the number, and you can ask any legal question you like. All right.
And I've just checked the website for Australia Post. If you search for compensation, it then has an explanation of delayed and lost items, how to apply, and information in FAQ. So check out the Australia Post website, William.
Perfect. There you go. Well, let's talk petitions. People always collect signatures on petitions. Does that actually achieve anything?
Okay, so legally petitions don't necessarily have force in law. However, online petitions with 10,000 signatures or more may or may not do a lot. However, if they're lodged through Queensland's formal e-petition process to the Legislative Assembly, formal e-petitions that meet the requirement, i.e. that they're about a matter that falls within the Queensland Government jurisdiction, that they're sponsored by an MP, may be tabled in Parliament. So once tabled, the government is required to provide a formal written response. So this provides parliamentary accountability. So it is possible to have a petition that's actually going to get listened to if you go about it the right way. The minister responsible, if there is one of these compliant petitions, must go on the public record with their position. That response is a public document which can then obviously be open to the scrutiny of the media and becomes part of the political history in the matter. So last week we were talking about the Springbrook Cableway. It's attracted exactly this type of organised petition from environmental groups, and the responses have been consistently revealed that the state government's support for the project is softer than the council's. The petition doesn't bind the government, but it does expose where they stand. So if you are passionate about an issue, you may want to follow the legal avenues, but also talk to your local MP and start an e-petition.
And look, a great example of that is the quarry down here at Burleigh. There were petitions, there were rallies, there were discussions with MPs, and it turned out to be a great result for the community here.
Excellent. So the power of the people, it's democracy at work, Colin.
Indeed. All right, second caller, we're moving on to Peter. Peter, ask your question of Andrew.
Yes, it's Peter here.
Morning, Peter.
I booked a tour with a travel company to Dubai and the Five Stars tour in Central Asia. But anyway, because of the Middle East war, they cancelled on me.
Mm-hmm.
And anyway, I actually paid in cash, and but they only gave me a credit more than $1,000. I paid over $10,000, and they kept back
over $1,000. When I queried it why, they said, oh, well, they had to deduct supplier charges and pointed me to their terms and conditions that they could do this. I just wonder where I sort of legally stand on this.
Peter, are they an Australian company?
Cancel it, and then they keep money back.
Are they an Australian company or are they a foreign company?
Oh, yeah. No, Australian company.
Okay, well, it would typically come down to what was in the contract or potentially based on Australian consumer law. Now, there is recent precedent for this. Over COVID, Qantas and Virgin were doing this a lot, where people were getting credits and then they were expiring very early, and people were very concerned about these credits. They ended up relenting and returning most of the funds or extending the expiry dates. But it often comes down to the actual conditions of the contract that you signed. So those terms and conditions are important. And this is only general advice, so I can't give you the specifics as to if there is a way that you can get out of it, but I would look at them very carefully and also put in a request if you have hardship or other reasons and ask them nicely for the rest of your funds. But it is a commercial consumer contract, and it would also be regulated by the Australian consumer law. So they can't be misleading and deceptive to you. They have certain obligations around warranties and returning funds. So I would look into those terms and conditions very carefully.
Yeah, because I never signed anything.
Okay, by your conduct, however, if they advertised that this tour was out, the Five Stands tour, and it said these are our terms and conditions, you went online and booked something or paid them cash, typically, or there would be a ticket given to you or some sort of a response that would also indicate their terms and conditions, and you would be bound by them. That happens quite often with online transactions. So yeah. You would want to ask them for a copy of what actually binds you. They have to provide that to you if you ask it to them, and then I would go from there.
Yeah, because I asked for a breakdown of the deducted costs, and they told me they couldn't give me that. How did they work out? That they could kick back so much money, and where were the costs? And they will not.
Well, that doesn't necessarily sound legal.
They just told me straight out they can't do it.
Well, normally if they want to rely on a term or condition, then they would have to explain exactly where it came from rather than just give you a generic figure. So I would be writing to them on that basis and say that you think that they're unlawfully withholding your funds, and can they please provide a breakdown of exactly where it comes from.
Yeah, I did write to them, and they didn't even reply to the email.
Okay, well, this may be something where you want to take to one of these non-legal options like fair trading then, or alternatively you may want to look at QCAT options, but I would go through the terms and conditions first.
Okay, then.
Does that answer your question, Peter?
Yeah, it gives me something to think about. Okay, thank you.
Good on you. All right, if you'd like to ask a question, just like Peter did, 0755 208888 is the number. Andrew, would something like travel insurance help Peter out in that circumstance?
Potentially. However, travel insurance often has a war clause in it that if there are things, war or terrorism, don't actually be covered by your travel insurance. So depending on how they've elected to call the reason for the delay or disruption to this particular tour, it may or may not have been covered. But Peter earlier said he paid cash. Otherwise, I would have suggested that he look at his credit card that may have actually included as part of his payment options and inbuilt travel insurance capability, which often happens on large overseas purchases.
Nice. Well, there are a few options, and it's interesting to explore. We're talking administrative law this morning. 0755 208888 is the number to ask any legal question you might like, just like Peter did to Andrew from Bell and Senior Lawyers. 0755 208888. 7 minutes left in the program. All right, what about writing directly to elected representatives? Does that work?
So, again, we talked about the quarry earlier, pressure being put on elected representatives. Our political system at the moment feels uncertain as to where we're headed, so people definitely want to lock in your vote. And Australia has a proud tradition of people contacting their local members with their opposition to things, and governments changing their minds. So it does work better than people think. It also works for education. You might even want to take up for CRB when they have Leon Ribello or Ray Stevens or others on our other shows, and query them about what their action is and the justification, and if they're aware of the impact it has on the people who are opposing it.
Look, it's that old idiom, the greater noise you make, as well as having force of weight of people behind you, the more people seem to listen.
What I would say, however, is if you are writing to or calling or dealing with your members of parliament, is to be specific. So just saying you're unhappy about something is just going to get you a generic letter to say, oh, well, we care about everyone and there's progress. If you're actually factual and specific around this development is proposed on a slope with a fire danger. There's a significant history of these things happening in the past and failures. What are you going to do to prevent the local community? With actual actionable questions that revolve around facts, you may actually get them to get past their letter writer and actually get to the individual member of parliament.
All right, moving back to administrative law, a lot of community groups set up websites, Facebook pages. What are the legal risks?
Okay, so we have had an episode on defamation in the past, and that's your primary risk for any of these particular groups. So just because you think you're promoting or campaigning for a good cause doesn't give you protection against defamation. If we go back to the definition of defamation from a couple of weeks ago, it's the publication of a false statement of fact that damages a person or company's reputation. It doesn't matter if you intended harm. It doesn't matter whether you believed it was true. If you publish a false statement of fact that damages someone's reputation, you could be sued. And then the actual truth of the statement will come out. Whether it's an opinion, it will come out and it will be tested if there was serious harm. So a practical example might be a community group opposing a cableway puts up a website. They might write, the developer has a track record of environmental violations in other projects. If that's true and they can prove it, and they're very careful about their specific language, they'll be fine. However, if it's not true or they can't substantiate it, and that developer has less than 10 employees, then potentially they're saying that they've got environmental concerns could impact their ability to tender for future work and cause them serious harm. And it's not necessarily just the person who posted that, it's potentially also the administrators of the group as well. So you will find on YouTube, for example, the ABC doesn't let you put comments on their posts for the reason that they're very worried that they're liable for the posts that anyone puts on their particular content.
Yeah, great point. And look, one of the conversations that was rattling around here with the volunteers was that this person was challenged by some of the statements they were making, and the answer was, I can say that, the politicians do. Now, I think that's probably a perfect segue into here's the pitfall.
Exactly. So the politicians, if they say something in Parliament, can have what's called parliamentary privilege. The fundamental nature of the democracy is that people can actually put things out there and have a fiery debate, and the politicians have decided they need to be protected from that. I believe that was used last week in Parliament to name 2 politicians that were apparently having a romantic relationship, and there's not a lot of comebacks from that. However, you and I, as members of the general public, don't have the same protections. So you have to be very careful. These defamation concerns can be very expensive to defend, even if you are in the right. So if you share other people's posts as well, there's another risk there. If you share from another group into your group and it has a defamatory claim, potentially you could also be seen as publishing that. And that's what happened in the High Court in 2021 in a decision called Voller, where anyone who operated a Facebook page or a public forum where third parties can post comments can potentially be treated as the publisher of those comments, and therefore they can be taken down by a defamation claim.
Yeah, okay, that's going to be an interesting one for us to examine down the track, because the platform themselves then potentially has an issue, but we'll come back to that. We've got a final caller this morning. Let's go to Malcolm. Malcolm, ask your question of Andrew.
Morning, Malcolm.
Yeah, good morning, Andrew. Andrew, what can you tell me? It's just heard only recently you can be booked for charged with drink driving on private property. Is there any truth in that?
It may depend on the definition of private property, but it relates to operating a motor vehicle. and it can relate to road adjacent areas. So depending on how a driveway or a thoroughfare can work, it's definitely not something I would recommend doing in any case. If you did write off your vehicle, for example, and you were under the influence, even if you weren't charged, the insurance company is almost less likely to deny it. But I think it would depend on the specific incidents. But it's normally revolves in operating a motor vehicle on the road or what's called a road-related area. But I could check out if you're just in a paddock. I'm not sure.
Look, I haven't been charged or anything like that. I just thought that it seemed like a considerable overreach by government to be able to do that. It might be understandable if, say, for example, that private property was also for public use. Then you could probably understand it, but I would have thought that's otherwise it's somewhat draconian.
And if they reasonably believe that you have actually been recently driving, they can ask for a breath test as well. So if you've pulled up in your driveway, you're not immune from them coming on because they have reasonable suspicion that you may or may not have committed a crime. If you're completely in a paddock, not on the road, I can see that there may be some overreach, but if you're potentially endangering the public, then I think that would be a reasonable thing.
A driveway on a private residence or a public car park. I've had a friend who mistakenly did something silly. He was working on a car in a public driveway, and there was a number of other sheds in the driveway. Someone called the police, and he was charged with drink driving, even though he was just working on his car in a public driveway.
And I've had a client who had been to the pub and realised he was over the limit and decided to sleep in the car in the public car park, and he was also charged. Your access to your keys and your ability to actually drive that vehicle is central to whether you're in control of it or not.
That's a different charge altogether, isn't it? Isn't that a charge of being in control of a vehicle whilst inebriated or over the prescribed limit?
Yes, but that is what your drink driving offence is. So, it is the same offence.
All right.
Thanks for that, Andrew.
Thank you, Malcolm.
Thank you, Malcolm.
Bye.
All right. Well, we are at the end of the program, Andrew. Some final comments, and we'll wrap it up.
Yeah, so we'll move on to a different topic next week, but admin law will close out here. If you are concerned about a decision, as we said, there's many options you can do. You can follow it through the courts and challenge the decisions on a legal basis, or you can go through Ombudsman, you can go through the Human Rights Commission. You can write to your local representative, you can start a Facebook group, you can put on a petition. So don't feel powerless if there's things that you don't like. There are plenty of ways that you can force a change.
All right, Andrew, thank you very much for your time this morning. Great information. I'd also like to thank all of the callers who interacted with the program. We'll look forward to your company again next week, Andrew.
Thank you, Colin. Thank you, callers. Talk to you next week.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777.